Good afternoon, everyone. I hope you are having a great Monday. It's a new week, and so I wanted to post a new video. Today, I am going to talk about cancellation of removal for non-lawful permanent residents. Now, this is a type of immigration application that is available to people who don't already have their green card status, who are in removal proceedings, who are in the immigration court process already. It is not a type of status that is available to people who are not in court proceedings. And I wanted to start with emphasizing that because I know there are a lot of rumors out in the community about the law of 10 years or getting your green card for your time here in the United States. And generally, those are very basic and very inaccurate descriptions of what a cancellation of removal case is really about. So let's talk about what that really is about. So a person who wants to apply for cancellation of removal has to demonstrate 5 things. 1, that they have been physically present in the United States for at least 10 years prior to the commencement of immigration court proceedings against them. And how you measure that date is actually a kind of complicated issue, and it's one the Supreme Court is going to issue a decision on sometimes this year. So don't take for granted that just because you've actually been in the US for 10 years that you necessarily meet that criteria. 2, that the person has been a person of good moral character for the preceding 10 years. 3, that they don't have any number of disqualifying convictions. Now, not all criminal convictions will disqualify someone from seeking cancellation of removal, but a lot of them will, and it's really important to get accurate advice from an immigration attorney about whether your criminal history might prevent you from qualifying for cancellation of removal at all. 4, and this is generally the most difficult part, you have to show that your U.S. citizen or green card holding spouse, parent, or child will suffer exceptional and extremely unusual hardship if you are deported. Now, we're going to come back to what that means in more detail in a minute. I just want to review the 5th and final criteria, which is discretion. You have to prove to the immigration judge that you deserve to stay in the United States, and that's a balancing test, right? It's going to have your bad things on one side, any criminal history, any past immigration violations, and then it's going to have the good things about you on the other side. Long-term presence in the U.S., strong family ties, work history, paying your taxes, owning property, volunteering in the community, going to church. Those are all going to be on the good side, and you have to show that the good side has more than the bad side does. But getting back to the hardship requirement, because that is usually what makes or breaks a cancellation case. Exceptional and extremely unusual hardship is really a very high standard. It is not my children would have less educational opportunity in my home country, or my spouse would miss me if I got deported, or it would be hard to find a job to support my family. All of those are forms of hardship, but individually and honestly, even in total together, those types of factors are not going to establish exceptional and extremely unusual hardship. Typically, an exceptional and extremely unusual hardship case is going to involve either a relative who has significant medical issues, maybe it's an elderly parent who has dementia or Alzheimer's, or some sort of serious physical ailments, really bad arthritis where they can't really get around without help, or a spouse who's maybe undergoing cancer treatment or has very significant psychological health issues, so maybe a history of anxiety or depression where they've been in therapy or on psychiatric medications for a long period of time, and where having their spouse deported would adversely impact their psychiatric health. Children with significant developmental disorders, perhaps autism, for example, Down syndrome, or children who themselves have some sort of serious health issue, physical or mental health issue. Or in the absence of a medical or psychiatric or developmental issue, you might be looking at a child with significant learning disabilities, perhaps a child who's on an individualized education plan and has been for several years, who isn't able to only get their education in the mainstream classroom but needs an aide or needs a lot of extra hours in a special education classroom, or is perhaps in a special education school setting all full time. this is always going to be a very individualized determination, and usually it's going to be a combination of these factors, not just one significant thing on its own that makes a cancellation case viable. So it's important to talk to an attorney to find out if you might qualify, and to really assess what kind of documentation you're going to need to make that case before an immigration judge. So feel free to reach out to us, 323-475-8716, to schedule a consultation, and we can evaluate whether or not you may be eligible for cancellation of removal in immigration court proceedings or any other type of immigration status or immigration defense that you should be bringing before the judge. Thank you, everyone. Have a great day.